Good morning friends, my name is Avinash Kumar. I am from Dr. Hari Singh Gaur Vishwavidyalaya, second of Law Department, LLM, second semester. Today I am going to discuss the case analysis of one of the important cases, the state of Punjab versus Sodhi sukhdev Singh. Citation of this case is AIR 1961, Supreme Court 493. And I would like to discuss the introduction first, that it is the rights of the citizens to get proper information and knowledge about the functioning of the government. The main basis of the government is disclosure of the information and to prevent the secrecy of the functioning of the government. But there are certain privileges that are given to the government but not to the general public. Like in England, first we have to discuss that in England there is the crown privilege. If we talk about it, it gives the crown prince a special privilege of withholding disclosure of certain informations or documents that are required to be discussed, and this privilege is known as the crown privilege. This privilege is based on one of the most famous maxims, that is the solus populi est suprema lex, which means public welfare is the highest law. If there is any, which means if there is any conflict for a valid claim of producing the document before the court, then public interest should be utmost important. But in this case, the crown privilege, the crown take the privilege of withholding certain documents or informations before producing before the court. The same goes in our country, that is India. In India, section 123 of the Indian Evidence Act talks about the same privilege that is existing in England. According to section 123, no one shall be permitted to give the evidence derived from unpublished documents relating to the affairs of the state, except under the permissions of the head of the department. Then only it can be produced before the court. If the head of the department claims that this document or this particular information refers or relates to the affairs of the state, then it cannot be published before the court. And in addition to that, the court doesn't have the power to inspect into those documents to validate if it claims or it relate to the affairs of the state. Now coming to the fact of the case. In this case, the respondent, who was a district and session judge, was removed from his post by an order from his service by the president. The respondent then made a representation to the Council of Ministers of the said state, because in the meantime the president's rule was coming to an end, and the administration of PEPS was entrusted to the Council of Ministers. The council expressed its views through a report, but still it demands the advice of public service commissions about the reappointment of the district and session judge. After the advice of the public service commission came through a report to the Council of Ministers, and after discussing it in the minutes of the meeting, the sessions and the district and session judge was reappointed to a post. But after that, the respondent filed a suit before the trial court that his removal from his service was illegal and violative of the different provisions. He then filed an application under Order 14 Rule 4 as well as Order 11 Rule 14 of the CPC for the production of documents mentioned in a list annexed to the application, which includes all the reports of the minutes of the meetings and the report given by the Public Service Commission to the Council of Ministers. Now next we will discuss about what are the issues that are involved in this case. Coming to the issues, there were some issues arise in this case, like under the provisions of section 123 and 161, whether the claim of the respondent was valid or not. Whether the second one is whether the documents in question do really fall in the category of affairs of the state. The third one is whether the disclosure of the documents would cause injury to the public interest. The fourth one is whether the decision of the High Court in rejecting the privilege that was claimed by the appellate was valid or not. And the last one is whether the present appeal is maintainable before this court or not. Now coming to the arguments by different learned counsels. First one is the learned counsel for appellant argued that the documents that are demanded by the respondent in this particular case falls under the category of affairs of the state, and thus privilege was claimed by the government, and according to section 123 of the Indian Evidence Act, the judge cannot force these documents to be produced before the court, because according to this rule the government enjoys privilege of producing the document before the court. But the learned counsels for respondent have urged before the court that the affairs of the state has a narrow meaning, but it also includes the power of the court to inspect on the documents or the informations to check whether the claim of privilege is valid or not by inspecting of the different documents or informations produced before the court. Now coming to the ratio decidendi of this case. Ratio decidendi means the principle on which the case is decided. The privilege to withhold certain documents or information to be produced before the court has been also discussed in different other legislations, like section 123 of the Indian Evidence Act, section 8 of the RTA Act 2005, the Atomic Energy 1962, and Commission of Inquiry 1952. Therefore, the ratio decidendi of this case, or we can say the principle that is established in this case, is that of the overriding and paramount character of the public interest, which means if there is any claim for privilege under section 123, then for the production of the document, and if there is a conflict between the public interest and the private interest, then the public interest would be prevail over the private interest. Now coming to the judgment part. First, this case was filed under trial court. The trial court urged the government to reduce the documents before the court that was asked by the respondent. Who was the chief secretary, claimed privilege under section 123 of the Indian Evidence Act and made an affidavit by claiming that what is the reasons before claiming privilege under this section. The trial court, after analyzing all the documents and the affidavit that are filed by the appellant, upheld the claim of privilege in favor of the state of Punjab. Now the respondent filed this. Now the respondent goes through the revision petition in the High Court of Punjab, in which the Punjab High Court asked the state for producing a document that was annexed in the application. After analyzing the documents and informations, the High Court overruled the decision of the trial court and upheld that and held that the documents should be produced before the court because these documents include important informations that is needed for this case to decide. Now the appellant further appealed in this present case in this present court, that is the Supreme Court of India. The Supreme Court of India held that after analyzing all the claims and affidavits filed by the respondent and appellant, held that the state does claim privilege under section 123 of the Indian Evidence Act, and the head of the department doesn't give the permission to be produced before the court to be valid and held a decision in favor of the appellant. But one of the judges have a slight different view that all the three documents that are the minutes of the meetings get the privilege under section 123, but the report or the advice that was given by the Public Service Commission does not claim the privilege under section 123 because the Service Commission is because the advice given by the Service Commission doesn't comprise of the privilege in comparison to the other three documents. Now there are certain other relevant judicial decisions that support the state privilege to withhold documents, like Duncan versus Camel Laird case, Earl versus Vass case, Robinson versus State of Australia, Glasgow Corporation versus Central Land Board, Khwaja Nazir Ahmed versus the Crown, RMDC versus Wire Parpia. These are certain cases where in all the cases the same decision was upheld, that the privilege was claimed and made valid by the court. Now coming to the conclusion part, a state privilege is one doctrine that gives the government to withhold the information or document by not producing before the court. To some extent, this is essential for the security of the nation, like armed forces secrets, various policies that are discussed in the minutes of the meetings, etc. Like Section 8 of the RTI Act also enlisted some of the informations that are excluded from the right to information. Which means these are the list that according to which the seeker cannot obtain the information because due to the security reasons. In the same way, Section 123 of the Indian Evidence Act talks about the privileges that certain documents should not be certain unpublished documents should not be produced before the court because it will hamper the government, not only the government but also the security of our country. But we should also keep in mind that it should not be over, which means not in every case the government should claim privilege if it doesn't fall within the category of the affairs of the state, because in the modern time of democracy, the base of the democracy is that the government should be openness, and the right to information should be given for the benefit of the public. Thank you.